Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the new public charge rule, which has been on the lips of many who are involved in the immigration process. We are specifically discussing this matter in the context of Americans who are seeking to bring their Thai fiancé from Thailand to the United States in a K-1 visa status. So, those who are looking for general information regarding the new public charge rule, we've already made other videos on this channel on that topic. We urge you to go check those out. But with respect to this video, this is going to be kind of Thai-centric for those who are processing K-1 visas through the U.S. Embassy here in Bangkok. So for those who are unaware, new rules have come about which have created they're cumbersome, I'll put it that way. And they are causing a great deal of consternation for many. Now, the thing to understand with respect to K-1 visas is the brunt of this is probably not really going to hit until dealing with the adjustment of status process in the United States to get the Thai fiancé regularized in the U.S. So getting married and then seeking a green card after arrival in K-1 status. There are implications to the public charge rule over here, especially with respect to the thresholds associated with income and assets necessary to prove an ability to support a foreign fiancé. But the brunt of this is probably not going to really be felt until the adjustment of status process. That being stated, it's still an issue that has to be dealt with and has to be dealt with, in a straightforward manner and effectively in order to see the ultimate K-1 visa issued. It's also going to have to be dealt with in a much more detailed manner inside the United States when dealing with the adjustment process. Probably a good idea to seek legal professional assistance with respect to this, as certain forms, especially, for example, the I-944, which is I believe they call it the Statement of Self-Sufficiency or Affidavit of Self-Sufficiency. I don't have it with me at this particular moment. We made a video specifically on the I-944 already, but that pertains specifically to the adjustment process in the United States, and those who are going to be dealing with that, it's a long form. There's a lot of work to be done with it. It's a lot, and dealing with adjustment in K-1 cases, I think, is going to be much less of a pro forma process. I think it's going to be much less of a formality than perhaps it was considered in the past. I never really considered it a formality myself. But in many ways, the person had already been adjudicated to come to the U.S., so dealing with the finality or, the sort of back end of getting their residence dealt with, yeah, there was an error. There was a sort of a feeling of inevitability with respect to those kinds of cases. That being said, now we're dealing with a different public charge rule, and as a result, we're dealing with various aspects of the changes in that public charge rule. And this will have an impact on adjustment of status to green card status for those Thai fiancés arriving in the U.S. with a K-1 fiancé visa.